Chairman of the State Legal Services Authority, West Bengal, Honorable Justice Tabopatra Chakravarti, Chairman of the High Court Legal Services Committee, Honorable Justice Arjit Banerjee, the President of the Mediation and Conciliation Committee, High Court, Honorable Justice Madresh Prasad, Honorable Justice Ura Ghosh, Honorable Justice Dinesh Kumar Sharma in absentia, who are members of the Mediation and Conciliation Committee, Honorable Justice Savishesh Bhattacharya, who is the Honorable Executive Chairman of Andaman and Nicobar Legal Services Committee, Honorable Justice Champa Sarkar, Chairperson of the High Court Legal Services Committee for Calcutta High Court Circuit Bench at Port Blair, the Honorable Judges who are attending this program, Honorable Justice Subrata Talukdar, Honorable Justice Subhashis Dasgupta. Very happy to see both of you today. The Learned Registrar General and her team of registrars, the Additional Director of the West Bengal State Judicial Academy, the Member Secretaries of the State Legal Services Authority of West Bengal as well as Andaman and Nicobar, and the Member Secretary of the High Court Legal Services Committees, the learned trained mediators who are going to be honored with the certificates today, the members of the registry, staff, special invitees, ladies and gentlemen. It is indeed a great pleasure for me to be amongst you to felicitate the newly trained mediators by handing over the certificates of appreciation who have undergone 40-hour mediation training program at the West Bengal Judicial Academy under the aegis of the MCPC as well as of the Honorable Supreme Court. I am informed that about 125 participants were trained, which include honorable judges, former judges of this court, and also former judicial officers, advocates from different districts, subdivisions of West Bengal, experts and professionals of different fields like journalists, psychologists, engineers, chartered accountants have been trained. Indeed, it is a very big task, and I congratulate the Honorable Chairman and the members of the Mediation and Conciliation Committee, as well as the patron of the Mediation and Conciliation Committee. Over the recent past, mediation has become a most sought after alternate dispute resolution mechanism in the country. Considering the fact that about 45 million cases are pending in the country, a need was felt to explore different methodology by which the cases can be disposed of expeditiously and finally without there is a chance of appeal to drag on the matter. So with this in mind, Section 89 CPC was amended, which all of you know, and how it became mandatory for certain courts exercising jurisdiction under a particular statute to mandatorily refer matters for mediation. In fact, 4 decisions of the Honorable Supreme Court had paved the way, and the most celebrated decision is in the case of Afcon Infrastructure, which all of you know. And more recently, that is in the year 2019, in the decision of M.R. Krishnamurthy versus New India Assurance, the court suggested a separate mediation law which led to the Mediation Act 2023. At this juncture, I would like to mention that this judgment was authored by Honorable Justice Sanjay Kishan Kaur, the former judge of the Supreme Court of India. His Lordship was the Chief Justice of the Madras High Court, and I had the opportunity to work under him. And it is at that juncture, the mediation movement in the Madras High Court had to take a giant leap. In fact, the Madras High Court is very proud to say that it is the first High Court in the country to have a court-annexed mediation center. And with the efforts of Mr. Sriram Panchu, who is one of the very well-trained mediators who was trained abroad, this center was established. So this, of course, since there was no enactment governing the procedure, it was largely recommendatory, and some people had absolutely no inkling about what mediation was. Often the word mediation is mistook and read as meditation. So the first time people, when they walked into a premises and saw a board, oh, this High Court has got a meditation center. Oh no, please read it properly, it is mediation, not meditation. So when I was transferred here and I became the executive chairman of SLSA, lot of these government departments, people who were IAS officers holding high positions, did not know anything about alternate dispute resolution. So when the first time when the Labour Department was invited, Mr. Raju Mukherjee was the member secretary, I said, why not we try for these Employment Compensation Act, small cases where leave is not regularized, transport corporations, tramway, etc. They said, no, sir, we thought this is something to do with the court system. We are not concerned about it. So thereafter we invited the members of the Labour Bar, and fortunately in the successive Lok Adalats, we were able to push through a couple of matters which they did not have any idea that could be resolved. So what could not be done in Lok Adalat was referred for mediation, and these private companies readily accepted it. So this was sort of how the mediation movement in India grew. And most of the people had an opinion that mediation is meant for white-collar people or high-value, high-profile matters. Nobody gave it a thought process. Even an issue regarding custody of a child can be mediated. Dispute between the parents and the children regarding a property can be mediated. And fortunately for us, this Mediation Act 2023 has been put in place.